the Supreme Court affirmed Bola Tinubu as president of Nigeria?
Well, one can say that the judgment of the Supreme Court may have clothed his presidency with constitutionality, because Section 235 made it clear of the Constitution that the decision of the Supreme Court is final, but it has not clothed his presidency with democracy, because democracy means the rule of the people, and it means that power must proceed only from the people. And let me tell you what the Supreme Court said that is very telling. Justice John Inyango Koro, while delivering JSC, while delivering the judgment, he looked right to his colleagues and looked left. He said, let us admit that the non-uploading of the result on the IREF portal reduced the confidence of the people in the election.
Reduced, but didn't eliminate it.
Good. That is how the judges talk. Reduced means it wasn't as credible as it would have been if the law was obeyed that said you should upload on the IREF portal for the people to view. And this is in line with all the decisions of the international and local observers.
But not so lacking in credibility that it made them decide that they were going to go against the decision of the lower court.
What they said was, look, the only result we have is the one presented by INEC. We do not have alternative result presented to counter it. Now, let me tell you the implication of that. In mathematics, I did mathematics and I did advanced level mathematics. If you're given a mathematical question and you go straight to quote the answer, they will probably say you stole the answer. You must start with quoting the formula and giving the
statements. Statistics.
Good.
You got to have the formula
before you give the answer.
Yeah.
You know what INEC did? They simply came and quoted an answer that somebody won the election against the express position of the Act. The Act said you have to compile, update, and maintain, polling unit by polling unit, all the results, and you must be ready to show it to any person or political party that demands it. And that is when you would now pronounce a winner. And I'm talking about Section 62, subsection 2 and 3 of the Electoral Act. INEC did not. They just woke up one day at the dead of the night, 4:30 a.m., and declared an answer, which we did not know the formula or the statements that they arrived at to get that answer. So how can you tell the petitioners to produce polling unit by polling unit the result to prove their election, where the institution that is bestowed by the power, giving 400 billion naira to do that, failed to do it? And then you're asking, where will we get it from? The credibility of this election will forever be tarnished. And I agree with the Supreme Court that the confidence of the Nigerian people in this election was reduced. And for me, it was destroyed.
But can you, strictly from a legal point of view, do you broadly accept and respect the reasoning of the court in reaching its decision?
The court gives decision issue by issue. If you give me the question issue by issue, I will give you the answer issue by issue. But like I said, the Supreme Court is clothed with the cloak of finality. I disagree with their judgment, but I accept it as a Democrat.
Well, let's go through some of the points that Justice Okoro raised. I mean, what is your assessment? I know you've touched on it briefly, but let's kind of go more pointedly into it. What is your assessment of his pronouncement on the IREV and electronic transmission of results? Because he seemed to have decided that it is not the ultimate method of collation.
Good. And that is where, with respect to the Supreme Court, they got that all wrong. And I'm talking about the law, not my opinion. The Supreme Court was romancing paragraph 93 of the regulations and guidelines of the conduct of election by INEC. Thank God, by even mentioning the paragraph 93, they have agreed that subsidiary legislation is part of our laws. Now, paragraph 93 is not even applicable to this petition at all. Paragraph 93 is in a case where there is no hard copy of Form EC8A. What you would do in a case where there is no hard copy of Form EC8A. It is not the case of the petitioners that there was no hard copy of Form EC8A. So the Supreme Court, even relying on 93, is even wrong. It does not even apply. But let me tell you what they did that brought the whole contradiction. Supreme Court was saying that uploading on iRev was not mandatory. Good. Even by the paragraph 93 they quoted. Paragraph 93 said, if Form EC8A is not there, you use the result electronically transmitted and you use the result uploaded on iRev to declare the result. So if the law does not mandate the uploading of result on iRev, where would you see it to use? This is by the paragraph 93, which they love so much, which is not applicable because it is not the paragraph that is responsible for collation. The paragraph that is responsible for collation is paragraph 48, A and B. I am surprised the Supreme Court did not even mention it at all. Let me tell you what it said. It said there shall be collation only when the collation officer confirms the veracity of the result in the beavers of the accredited voters and confirms, I'm talking about B now, of 48, of the number of votes that is transmitted electronically into the system. That if the collation officer does not have it to confirm, to verify, there shall be no collation. This is by paragraph 48 AB. Meanwhile, paragraph 38 I and II said INEC must electronically transfer and transmit using beavers to the electronic system. And you do a scan copy of the result and upload it on iRev. These are two different things. Transmitting to the INEC server or whatever you call it and uploading on iRev. These are two different things. Stated in paragraph 38, I and II. Let me tell you something. Supreme Court talked about section 60, which talks about transfer. They did not mention anything about section 64. And section 64 is the section that deals with collation. And I'm talking about the Electoral Act. And section 64, 4AB, made it clear. The collation officer shall collect result and announce it subject to his or her verification of the manual result with the result in beavers and with the results electronically transmitted. I'm talking about section 64, 4A and B. Supreme Court did not mention it. So how can you be mentioning sections that has nothing to do with collation? And then you're telling us that it is not in accordance with the law.
Well, you sound like you make a convincing argument. Maybe you should have been the lead lawyer.
The Commission will also transmit polling unit level results in real time. The transmission of polling unit level results is also a mandatory provision of the law, as Section 64, subsection 4 of the Electoral Act has made it mandatory. We canvass for the inclusion of the beavers and the electronic transmission of results in the Electoral Act. We therefore have a responsibility to keep faith with our own innovations aimed at the conduct of transparent elections driven and propelled by technology.
Because transmission is when you vote and it goes to the server. What we have passed, and I can recollect this vividly, because I read that act when it was a bill several times, is to transfer. After all the paperwork that we normally do are done, the agents and everybody there, security, everybody will have the papers. INEC will snap or scan or snap the result sheet and transmit or transfer or whatever it is. that whether it is transmit or transfer is that thing that is captured with beavers, the results. And for me, my understanding is if any result that was captured and sent differs from something gotten somewhere, that one is illegal. And only the courts, it's not us here that can do. So we urge INEC to follow the Electoral Act. And for me, my understanding is if any result that was captured and sent differs from something gotten somewhere, that one is illegal. And only the courts, it's not us here that can do. So we urge INEC to follow the Electoral Act and other laws.
Welcome to my channel, where we discuss everything and all things politics, especially about the 2023 presidential election held in Nigeria on February 25, in which a supposed closure was brought to it on October 26, when the Supreme Court hurriedly sat to deliver its judgment. And if, after listening to Kenneth Okonkwo, one of the spokespersons of the Labour Party and one of the lawyers of Peter Obi, if after listening to him now, and you still believe that justice was done or was delivered on October 26th, I'm sorry, your parents deserve to go and ask for a refund, because the money spent in your education was a waste. Kenneth Okonkwo has let it bare. This is a total miscarriage of justice. There's no debate about it. On the issue of transmission of the results, INEC admitted in the presiding judge of the Supreme Court, that's Inyang Okoro from Akwa Ibom State, emphasized that the non-transmission of that result on real time brought reduction in confidence of Nigerians in the electoral process. And Kenneth Okonkwo was right in saying that it means that the election itself lacked credibility. That is no different from what the European Union monitoring group said about the election. The European Union group, go and watch their presentation. They said they didn't know how INEC got the calculation to the result it announced. That was exactly the case Okonkwo made in this video. INEC brought an answer without showing the process of which it arrived at the answer. And if you ask, they say go to court, because they know the kind of court that you are going to meet is the like kind of court that the Supreme Court became. Because they know you're just going there to waste your time. It's unfortunate. And then there's an important thing he said there. Okonkwo made a very interesting argument. He was talking about that the Supreme Court was blaming Labour Party and PDP that they did not bring the result to counter the result of INEC. That they are acting based on the results given by INEC. That they didn't have alternative result to counter the result of INEC. But INEC delivered a result that they did not show how they got the result. That was why Okonkwo was livid. And he said it there, he said, in mathematics, you have to, even though you have to show formula how you arrive at an answer. INEC just presented an answer, rushing to declare Bola Ahmed Tinubu the winner of the election. saying that he got 8.7 million votes. And he said it, Okonkwo was right. When you are able to show only the answer, you didn't show the processes, it means you stole it, which is exactly what happened. They stole the mandate. INEC stole the mandate. It was obvious that it was a fabricated result, because there was no mathematical equation to show how they arrived at the answer. And the most cynical of all is to say that Labour Party and PDP, they failed to bring unit by unit results. Unit by unit results to counter the results that INEC had. Did INEC present unit by unit result and arriving at their conclusion? When they confronted them at the International Conference Center, where the National Coalition Center was, there was altercation between the INEC chairman and Dino Melaye, who was one of the electoral officers of PDP. He said he will look into it. Then at the end of the day, what he said that if you are not satisfied, you go to court. And the man rushed and announced the result, which they literally cooked up. Since they didn't show us how they did it, the European Union said it literally, that nobody can verify. It cannot be verified how they got their result. Because if you participate in a mathematical class, you get an answer. Every other person can look at the result, the process. Every examiner can look at it to know the process through which you arrive at an answer. This one, there was none. And this was some of the spurious argument that was being made by people like Otitoju of TVC, saying that they could not bring pulling unit by pulling unit result. Even INEC themselves, that they budgeted over several billions of naira for them to go do pulling unit by pulling unit results, could not show it. And then they expect political parties to show it so that they can use it to counter the INEC results. If not in a country like Nigeria, that's the only place you can get this kind of situation. And people are celebrating that there's a closure. There's no closure to this matter. There's no closure to it. What is obvious is that the mandate was stolen. But like Okonkwo said, they have clothed Tinubu with constitutionality, but they didn't clothe him with democracy. He is not the choice of Nigerians, but because the Supreme Court has clothed him with constitutional, he has the constitutional power to now say that he has 4 years. But that was all. He has already lost the battle for the hearts and minds of Nigerians years ago. Even before the ballot was cast, Nigerians never supported the APC, and that's what Bola Ahmed Tinubu, and he knows it. Nobody celebrated his victory, except his cronies. There was no rejoicing. At least Buhari can talk about the fact that there was celebration. Even in the north, even in the southwest where Tinubu came from, there were no celebrations when he was announced as the winner of the election. That says a lot, that he is not with the people, and the people are not with him. But the Supreme Court has given him, has clothed him with constitutionality and legality to sit at top of the country's resources and administer it anyhow he likes. It's unfortunate what happened. So, like Okonkwo asked, how can you tell the petitioners to produce polling unit results by polling unit when the institution that is bestowed with the power with 400 billion naira to generate polling unit by polling unit results could not do it? And the law was clear about it, that when they generate it, political parties can then request it from them. And you can see how they were prevaricating in releasing the information to the parties. because they were not sincere. So I really admire Kenneth Okonkwo. He's able to, and those who still think that anything good came out of the Supreme Court, let them know it. From his assessment, you know that nothing good came out of it. There's absolutely nothing good that came out of it. The only thing that came out of it was that Tinubu now has the mandate of the Supreme Court to claim that he has 4 years. That's the only thing. Nobody will dispute that with him now. He has 4 years. Now look at some of the issues that Okonkwo raised. Look at the issues he said, especially about the transmission of a result. And it's good. That was why it's because of that I showed you a video of INEC spokesperson Festus Okoye. You saw his video on INEC on the transmission, electronic transmission of result, where the Supreme Court claimed that it was not compulsory. But you saw what, and you saw that he was citing the same section 64 that Okonkwo was citing. That was what Festus was citing to show that it is compulsory. It is a shall. It's not maybe. That's section 64, 4A and B. Is it Okonkwo that told Okoye to read out that section, or promise that they will do that it is compulsory, that it is not a question of by choice, that it is compulsory, the electronic transmission of result? And then Supreme Court, justices of the Supreme Court. So you want to tell me that they are not aware that it is compulsory? The Supreme Court, so they need to return the salaries they were collecting if they say they are not aware of that section that Okoye read to show that it is compulsory, electronic transmission of result. Then they should refund the salary they have been collecting. They don't deserve to collect that salary. I like the way Okonkwo put it. And talking about the electronic transmission of results, you can see the Senate President, former Senate President Ahmad Lawan, what he said there. He said that when there are disputes about the outcome of a result, that the one that is captured with beavers and transmitted, whatever it is, that is the one you use to judge. If that is the one to use to judge, it means that it is compulsory. If there is a dispute, you saw him. The people that made the Electoral Act, he said if there is a dispute, that one that the people are talking about is fake. That the one that is real is in the one that is uploaded, snapped, and uploaded by INEC. That is what is called electronic transmission. And the Supreme Court justices sat down and said that it is not compulsory. And they were quoting wrong paragraphs as identified by Okonkwo. He said the Supreme Court was romancing paragraph 93 of the regulation and guidelines of the conduct of the election by INEC. He said, thank God that they even mentioned paragraph 93. They have agreed that the subsidiary legislation is part of the laws. And he went on to tell us what paragraph 93 is. He said, now paragraph 93 is not even applicable to this petition at all. Paragraph 93 is a case where there is no hard copy of Form EC8A. What you will do in a case where there is no hard copy of Form EC8A. It is not the case of the petitioners. It's not the case of the petitioner that there was no hard copy. No hard copy of Form EC8A. He says, so the Supreme Court, even relying on 93, is even Wrong. It does not even apply. And he said what they did was a contradictory something. He said that the Supreme Court was saying that uploading on Arif was not mandatory. He said, good, it's not mandatory. They said paragraph 93, they were quoting, said that if Form EC8A is not there, you use the result electronically transmitted and you use the result uploaded on Arif to declare the result. And they will, if the law does not mandate the uploading of result on Arif, where will you see it to use? And you see the former Senate President, Ahmed Lawan, that was what he was saying there. Because that compulsory uploading to the Arif was what you use when there is a dispute between the hard copy results between the polling agents. If Labour Party agent has a different result, PDP agent has a different result, others have a different result. You say, okay, what was it that was uploaded? What was transmitted? What was captured by beavers and transmitted will be the guide. Now, if that one is not compulsory, what will you use? And the Supreme Court say it is not compulsory. And the people are hailing them that they delivered justice. They didn't deliver justice. What they did was they did what Okonkwo actually said, that they were able to clothe Tinubu with constitutionality, but they could not clothe him with democracy. That is it. And Okonkwo now quoted the real source, the real something they're supposed to have done. He said the paragraph that is responsible for coalition of result is paragraph 48A and B. He said that he's surprised the Supreme Court did not even mention this. And he started quoting from there. And that section was saying that there shall be collation only when collation officer confirms the veracity of the result in the beavers of the accredited voters and confirms it. That's section B. And the number of votes that is transmitted electronically into the system. You compare this thing before you collected the results. And he went on to say that if the coalition officer does not have it to confirm, to verify, there shall be no coalition. So if there is no electronic transmission of results, there is no collection of results. That is what it means. So INEC just and the Supreme Court just scam Nigerians. That's what it means. They just scam Nigerians as they talk in local balance. Because what are we talking about? How can you say that it's not compulsory? You saw Mike Okoye. He said it's compulsory, that it is not optional, and that they are going to go ahead with it. And that after spending so much money and resources on this electronic transmission of results, that there is no way that they are going to abandon it. And that issue rose because there were fears that they may abandon the electronic transmission of results. The reason why many people registered to vote in the last election was the confidence they have that there will be electronic transmission of results. If not, Nigerians would have treated 2023 presidential election like elections before it, and many wouldn't even bother to go and register to vote. And then the Supreme Court could stand there and say that INEC has a choice, and INEC themselves being dubious in their own character, because the Okoye that was reading the video you saw is a member of INEC. He's a commissioner in INEC. Why didn't he say it in that in that statement, in that interaction with the media, that they have option, that transmission of electronic transmission of result is optional. Why did he say it's mandatory? You heard him clearly. He said it's mandatory. And you tell me that the Supreme Court of Nigeria does not know. If you believe that the Supreme Court of Nigeria does not know that electronic transmission of result was compulsory, that it was a shall, then even you should demand, your parents should demand for the return of the money they paid to have you educated. It means that you are part of the problem of Nigeria. You are not part of the solution. It's unfortunate what happened. It was a total miscarriage of justice. I will advise everybody to watch that Kenneth Okonkwo's interview again. Watch it again. Take pen and paper. Take note of all the citations he was making. Go and confirm it. Of course, the one he cited about the electronic transmission of result, that's section 64. He got it right too. The same thing was cited by Festus Okoye. That's Festus Okoye that I went to call him before I made a mistake. I said Mike Okoye, Festus Okoye. And is one of the commissioners that's in charge of communication or voter education. That's section 64. We can listen to Okoye. We'll go and check that Okoye assurance that electronic transmission of result was mandatory. It was mandatory. That is, Okonkwo cited it. It wasn't Okonkwo that wrote it. It is in the Electoral Act. It is in the Electoral Act. So what else are you talking about? What we witnessed on October 26th was a clear miscarriage of justice. That's my own interpretation of it. And no, any reasonable person will know that there was a miscarriage of justice. There was a miscarriage of justice. And Okonkwo has led credence to it. The man I brought to you here, Festus Okoye, has also led credence to it because he said it was mandatory. What is the difference between mandatory and compulsory? What is the difference between shall? And the electoral I was talking about shall. Shall. It didn't say may. That's section 64 about the transmission of result. So definitely, what the Supreme Court did was a miscarriage of justice, but they have succeeded in clothing Bola Ahmed Tinubu with constitutionality. He can now enjoy his 4 years uninterrupted. But the country has been conned. Thank you for watching this video. And if you are new to my channel and you have not yet subscribed to my channel, please subscribe to my channel. Hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you'll be among the first to know. God bless you. And please don't forget to like this video, because when you like it, God will rank it high and recommend it for more people. Thank you, and God bless you and yours.